The Electoral Court is today hearing several appeals by several political parties. Among those who have come before the court is the Umkhonto WeSizwe Party. MK Party is contesting a verdict by the Electoral Commission on former President Jacob Zuma's ability to stand as a candidate in the 29 May general elections. For more on today's court proceedings, I'm joined by SABC News reporter Zoleka Qodashe. Zoleka, good afternoon. Thank you very much for joining us.
Good afternoon.
No, it's a pleasure to have you with us. Now, you've been following the court proceedings since the early hours of this morning. Quite a lot coming out. Perhaps take us through just the Labour Party as a start, because it seemed as though the legal representative of the Labour Party crystallized the issues, which are quite similar for a number of parties, around them being unable to upload their data just before 5 p.m. because it malfunctioned.
That is correct, Umkhonto, and that is what a number of parties have raised before the Electoral Court today. Now, the issue of jurisdiction was not a concern because there are decisions of the Electoral Commission that have been taken to the Electoral Court today. And so the Labour Party essentially argued that because of this, because of what they say is the dysfunction of the portal of the Commission, they were unable to upload some of their documents in time, and that is in relation to the candidates list. Now, we know that deadline was the 8th of March, which was last month, and so a lot of parties coming and saying that because of that, and if they argued that should this not be dealt with, then it would not be in the interest or would hamper the Electoral Commission's ability to hold free and fair elections.
Now, Advocate Hopkins for the Labour Party stated another important fact, that in fact the portal is new. It's the first time it's being tested, and according to him, he felt it was quite abused on the 8th, that there was a strong likelihood that it would malfunction on that day in particular because it was the deadline. Just unpack that for us.
Well, the primary question I think that was before the court today was whether the failure of some parties and some maybe independent candidates to upload some of their documents is on the part of the Commission or whether it was on the part of the parties. Now, the Commission says that 87 political parties were able to upload their documents, and 10 independent candidates were able to upload their documents as well. And it says that, well, there's a dispute of facts here because the Commission says one thing and the parties that are aggrieved say another. But what was also critical before the court was, as Hopkins was saying, the decision of the Commission not to extend the timetable, the election timetable, and asking the court to review that decision. Now, we know that the Electoral Court reviews decisions or appeals that have been taken and exhausted through the Electoral Commission as prescribed in the Electoral Commission Act. And so that is what Hopkins was arguing, that they would like that to be reviewed and asking for also an extension in terms of the portal, that the portal just be as a just and equitable remedy, that the portal be opened perhaps for a day or two so that they are able to complete the process for themselves.
I then heard the IEC's legal representative come in and say it's not as simple as they might think, that you just open it for a day or two for parties to submit their candidate list. What that would ultimately mean is that they have to essentially take everybody back to the 8th, when the submissions were still, they could still receive submissions from candidates. Now, in that essence, it means everything that has happened since that point would now amount to nothing.
Well, Hopkins came very strongly in that regard, saying that while the Electoral Act, Section 20 of it, gives the Commission the ability to amend the election timetable. Now, he referred to utterances that were made by commissioners of the IEC saying that this was set in stone. He says, in fact, that is not the case, and also argues on a basis of rationality because the statutory provisions allow you to make amendments to the electoral timetable.
But what would be the implication? Because when listening to the IEC, it seems as though the implication would be to postpone, because they say in essence they'd have to now do everything over, and that would mean at least postponement by a month.
Well, that might be the legal implication, but I think the IEC would be able, depending on the judgment handed down by the court, would then have to reconvene and see how to take that matter forward.
How did the judges receive the statement or argument by the IEC's legal representative when he stated that, you know what, in as much as they cannot say with certainty that there were no political parties that would have been kicked out of the system, what they can say with certainty is that they made sure that every political party had an opportunity to participate in these elections, and that here they had ample time to upload. The system, the portal was open on the 23rd of February, but then they went on to state but that the Labour Party opted to then upload its documents 30 minutes before the deadline on the 8th of March, when it was open since the 23rd. What was the reception from the justices on that?
Well, the justices asked essentially to what extent the parties would be prejudiced by the failure of or the technical glitches of the portal of the IEC. And essentially Hopkins also coming in there and saying that while it would not be in the interests of free and fair elections as prescribed in section 190 as well of the Constitution, which stipulates that the Commission, part of its mandate is to ensure that elections are free and fair.
And then I want to take you to another interesting political party that is also appealing its petition to the court, the MK party. A lot of people are looking to hear their submissions. I understand that the court is still currently in session because there's quite a lot to get through. The judge even stating that they might go through up until midnight. Now, in just looking at their papers, since they haven't yet argued, they are arguing or appealing on 3 grounds, among them being the inability of the IEC to furnish them with details or properly communicate to them that their candidate had now been excluded. Talk to us about this.
Well, that is what you see when you read at first glance the papers, right? And they say that they were only notified or they were only aware of this decision by the IEC when the announcement was made last week, and says this is not procedurally fair, right? But what the other argument that they make is that essentially because the section that has been invoked by the IEC is section 47 of the Constitution, which prescribes, well, says that any person that has been convicted of an offence may not stand for public office, particularly in light of the sentence. So, for example, if you have served 12 months or more without the option of a fine, then you are not able to stand for public office. And the MK party also saying that, well, the IEC acted ultra vires, that is outside of its power, by invoking that section. Also stating that, you know, because we know that the former president was guilty of contempt of court as handed down by the Constitutional Court, saying that's a civil matter, and simply because criminal proceedings or a criminal sanction was then invoked does not make it a criminal offence.
And I just saw in their papers that they also state that parliamentary membership is not within their purview.
Exactly.
That would be something that is ventilated in Parliament. So they need to allow the processes to continue. And at least those are their submissions. We'll have to find out what the Electoral Court has to say about all of that. Zoleka, thank you very much for your insights this afternoon. Very interesting case currently underway. That's Zoleka Qodashe, SABC news reporter who's been monitoring those proceedings for us.